Judge Skarin, welcome to Constitutional Chats, and thank you so much for joining us today to talk about the state court system. We're going to let you take 3 or 5 minutes and give us an overview, and then we're going to come back and ask some questions.
All right. Well, thank you very much, Kathy, and I appreciate the introduction and also the opportunity to be here. So let's dive in. Let's take a quick talk about what I do and how state courts in America are functioning and why we have state courts instead of just having a federal court system. So let's just start with the basics. There's no requirement for how state courts are structured. States get to decide how they want to do that. Most, however, follow the same structure that you might be familiar with from the federal system. There's a trial court where questions of fact are decided. That's where you would have a jury. That's where you have witnesses. That's where you have lawyers come in and make arguments and ask questions. Above that, you have an appellate court for any errors that are alleged to have happened. In other words, if anybody thinks that I made a mistake in my job. And then above that, you have the state Supreme Court in most states. The state Supreme Court is not going to take every single case. They're taking cases that are just a matter of importance to that particular state, much as the U.S. Supreme Court only hears cases that relate to important issues for the nation. There can be significant variations. If you look across the states, for instance, Texas has not one, but effectively 2 Supreme Courts. They have their state Supreme Court, but then they also have their Court of Criminal Appeals. The Court of Criminal Appeals, as its name suggests, acts like the state Supreme Court in Texas for criminal matters. So all that you need to know right now is the states have the ability to change the structure of their state court systems as they choose, but most have chosen to follow a 3-tier system like you would see in the federal system. You also need to understand state courts are the primary courts in America. Federal courts tend to get more attention. You'll see them in the news more often on average, probably, but think about just the volume of cases. In 2018, which was the last year that we have data, there were approximately 83.8 million cases filed in state courts across America. By contrast, in federal court, same time period, there were about 359,000 cases. So 84 million, 350,000, a lot more going on in terms of litigation in the state courts. And similarly, you have a lot more state court judges. There are about 30,000 judges in state court in America, compared to 870 authorized federal judges, federal Article 3 judges. You have a few more bankruptcy judges, magistrate judges, a few more retired federal judges, but call it 30,000 to 870, a lot more state court judges. What that means is if you are thinking about going to court, and hopefully you won't have that problem, but if you're going to court, you're probably going to interact with a state court system in the course of your life, whether that means you're there for something as simple as a traffic ticket, or you're there as a witness in a criminal matter, or you get called as a juror, or there's a divorce issue, or a will issue, or a small business dispute, anything of that nature. On average, you're probably going to end up in front of a judge like me in a state court system. And I want to touch briefly on how do people become state court judges. And the short version is, again, the states have the ability to set up whatever they would like in terms of structure for how they want to select their judges. The podcast recently covered judicial selection. So I'll just mention some judges are elected, some are appointed for life, and there's some combination of those depending on the state. That's in contrast with the federal system where the president nominates a judge, the Senate confirms that judge, and they hold office during good behavior. In other words, you have to impeach a federal judge to remove them. Types of cases that are heard by the state court system. The short version is state courts in general can hear any type of case, and federal courts, you have to have a specific reason to be in federal court. So when you think about federal courts, you need a hook to get into federal court. A constitutional law issue, a matter of federal law, a case involving an ambassador, bankruptcy cases, disputes between citizens of different states if the amount of money at issue is large enough. Bottom line, there has to be a specific reason. State courts, you don't need a hook unless there is a specific reason, something like bankruptcy that's been excerpted out and given to the federal courts to handle exclusively. You will be in state court. And the other important piece that people often lose sight of is state courts are the final word on matters of state law. So we tend to think, well, if you have a dispute and you want to keep appealing it all the way, I'll go to the US Supreme Court. And that's true if there's a federal issue. But if you're in, say, Illinois, where I sit, and you have a question about what the Illinois state constitution means, or you have a question about what a state of Illinois law means, the Illinois Supreme Court is the last word. And if the Illinois Supreme Court rules and you ask the US Supreme Court to hear that case, they will deny it as having a state question. And they'll say, we don't have the authority to decide that because that is something that is given to the states to decide. So you need to think about that in terms of how state courts are structured. They get the final word on state law issues. And so why do we have those types of distinctions? Why are state courts the final word on their own laws? Why do we have state courts at all? Why can states structure their court systems as they see fit? It really comes down to a concept that if you've been listening to this podcast, you've probably heard before: federalism. When this nation was set up, the agreement was we're going to have, well, at that time 13, but now 50 co-equal sovereigns, the states, and they are going to, within their spheres, have the authority to make decisions about what is best for their citizens and how they think they can best preserve their citizens' liberties. And so as a result, you have the umbrella of the federal government and you have the umbrella of the federal court system that will address some issues. But in general, we made the agreement as Americans that we are going to allow the states the flexibility to experiment with their court systems, among many other things, in the way that they think best. And we're going to have certain guidelines. You have now constitutional limitations, for instance, procedural due process, the right to confront witnesses, right to a jury trial, at least in certain instances, things of that nature that are sort of guardrails. But within those guardrails, the state court systems are set up as we, the people, choose to set them up. So that's at least a quick overview. And why don't I throw it back to Kathy at this point to for our next step here.
Okay.
Well, thank you. And I'm probably going to throw it to Janine.
That works too.
All right. I have been watching. I'm going to ask elementary questions because sometimes we have a lot of younger students.
Sure.
And one of my questions is, I was watching a court case on television yesterday, and my daughter thinks she might want to be a judge someday. And I think the whole process of it is mesmerizing, and what you do and the level of knowledge that you have to have is extraordinary. And there was this moment during this trial that I was watching on television yesterday where something was asked about a witness that was in jail, and there was something about Fifth Amendment, and then that was from the prosecution, and the defense stepped up and said, "Wait a minute, you can't do that." And then on national television, there was this sort of pause for about 20 minutes where I could see the judge's wheels just turning. Mm-hmm. I understood how they felt, because it's sort of like, as an actress, if you know that everyone's watching you and suddenly you just can't think, because or when I try to do math, I'm really good at math, but if someone's looking over my shoulder, I suddenly can't think about how to do anything in regard to math, and I love math. So there was just this moment where I could see that the judge was feeling really perplexed about how to solve this issue. And so my question to you as a judge is, how do you know everything there is to know about the law at your fingertips to make these crucial decisions?
Well, the short version is, anyone who tells you they know everything is not telling you the truth. But with that in mind, there are certain issues that are going to come up over and over and over again. Things like, and I don't know exactly what you're referring to, but if you're talking about at a trial, an objection to a question, someone saying the question that's being asked is improper. There are certain categories of legal topics that a trial judge, or frankly a trial lawyer, should have at their fingertip to know what is and is not allowed. if you have something that's more complicated or more unusual, one of the nice things is, to a certain extent, you can take the luxury of pausing. You can always say, I need to hear from the parties. I need to understand what they think the law is. And you can say things like, and I've certainly done it, we're going to finish our proceedings today, and then I'm going to need the parties to brief or write me essentially small essays about what they think the law is that should apply. And I'm not going to make a decision until I get the clarification that I need and until I can take the time to make that decision. One of the challenges that you have, and your question, Janine, highlights it, is sometimes you don't have the ability to do that for whatever reason. And sometimes then what you will see judges do, and I've done it, my colleagues do it, I've seen it happen when I was practicing law, you take a break, you go back to your chambers, and you research the issue. You might walk down the hall and talk to one of your colleagues if you have the benefit of being in a courthouse that has multiple judges, as I do. And you might pick their brains and see, have you ever dealt with an issue like this before? So there are a number of different ways that you can deal with it, but no one should ever think that a judge is a universal fount of legal knowledge. By definition, all judges are generalists to some extent, some more so than others, depending on what they do. And that means that you have an obligation, when you have the ability and when you don't know the answer, to pause and try to figure out the answer the best that you can.
There you go. Well, he did dismiss the jury.
Yeah.
And they went into it while they figured it out. And I just thought, oh, well, that's just really, really, really fascinating. And I suppose that when if in your state, obviously there are many judges in every state that are elected, you want to make sure that your judge, as you're speaking, I'm realizing your judge has a lot of, I suppose, trial experience.
Typically that will be the case, but that goes more into judicial selection. And there are a lot of different ways to conclude whether or not someone is a good judge. It's also going to depend what type of court you're dealing with. If you are dealing with an appellate court, they're never going to see that drama moment that you're referring to, where you've got a jury there in the box and you have witnesses on the stand and you have lawyers who are asking questions and making arguments. That only happens at the trial court level. Once the trial is done and there's been a declaration, here's what happened, here's what the result is, here's either someone is found innocent, someone's found guilty, someone needs to pay money, whatever the outcome is, then you take that up to the next level if you wish to do so, and you can appeal that case. When you do that at the appellate court, there are no witnesses there. They have literally paper documents that record a transcript written down of all the words that were said at the trial. And they're reading cases and they're checking the law to decide whether or not a mistake was made at trial. And they will never see any of the witnesses. And often they will never see any of the parties unless the parties themselves choose to come and watch an oral argument there. And that maybe goes back to your other question, which is, how do you know what the answer is in the moment? Well, even if a trial judge makes a mistake, we have built into our system, both federally and in the state courts, the ability to ask another set of judges to look over the trial judge's shoulder and see, were all of this individual's rights preserved? Was the law applied properly? Were mistakes made? And if not, we can fix it.
That's like a check and a balance that makes our founding documents so exceptional, really.
Sure.
is this process. Two quick questions, and I want to pass it to Tova. You in per state, they can all make up their own rules about judges, but primarily there are some that are elected and some that are appointed, essentially, within the state. In
Illinois, you're saying?
Well, yeah. Well, per state, I guess they can choose. Well, in general, perhaps, but I guess you wouldn't know the answer to all 50 states, but in your state, I guess you could give an example of
Yeah,
Illinois.
and you can there are articles that you can look at. The area of judicial selection has been one that's been addressed fairly extensively in recent years, but you will have different variations. In some states, the governor will appoint people to fill court vacancies. In other states, you'll have an election where judges are on the ballot just like any other candidate for office. In Illinois, if there's a vacancy, the majority way that positions are filled is the vacancy is filled by the Illinois Supreme Court, but then at the next election, whoever is appointed to fill that vacancy has to run for re-election, essentially. So they're in the position for a period of some months before the next general election, but at that point they run for re-election. So there's a lot of different variation, and there also are, in some states, there are various committees that assist in making recommendations as to who should be appointed or not to a position.
So did I zone out on something? Did I miss something? Are all state judges elected unless there's a death or something comes up and one needs to be appointed to fill a vacancy until the
Not
next
at all.
election?
It varies dramatically. It varies dramatically by state. And in some states, there's no elective process whatsoever. And in other states, all you have is an elective process.
Interesting. It'd be really interesting. So last question, I guess. Is it in Illinois, do you have some state courts or appellate courts or even the Supreme Court? Do you have some judges that are appointed and never elected and some that are elected? And how is that decision made? I guess the governor make that decision or the state legislature make that decision in Illinois, but also, gosh, how would you figure out which one gets appointed and which one gets elected?
So in Illinois, it's set up in the Illinois State Constitution, which was last amended in, I believe, 1970, either 70 or 71. And it lays out the process for people becoming judges. The short version is that all of our judges are elected with the exception of some trial judges. Some trial judges are appointed by some of the other trial judges and some of the elected trial judges. But then at each level, trial, appellate, Supreme Court, if there's a vacancy, that vacancy is filled by the Illinois Supreme Court until such time as the next election occurs. It's a little bit messy, it's a little bit complicated, and I apologize, there's not a cleaner answer, but all that to say, that's the way that the people of Illinois, when they last modified or enacted the state constitution, that's how they set that up.
Fascinating, because when I vote, I see all judges that are on the ballot, and so that's why one of the reasons I wanted to do this study. I've always been very curious, and I guess if you really want the short and the long answer of that is, if you want to know in your state why or whom is appointed by the governor or the legislature, or who is elected, you just have to know your constitution, your state.
You're going to start with your state constitution in all likelihood. Your state constitution will either itself tell you exactly how judges are become judges, or your state constitution will say the legislature can make rules to decide how people become judges. It'll tell you one or the other thing. So either the Constitution will tell you, or the Constitution will say, legislature, go pass some laws to explain how people become judges, one or the other.
Fascinating. All right. I could ask a zillion questions, but I'm going to share. And now it is Tova Love Kaplan's turn. And Tova, you can then toss it to Jewel. Okay.
Thank you so much. I'm learning a lot. So I was wondering, have the court systems of states changed significantly over time, or by and large, have they kind of stayed consistent? And then what do you think accounts for the differences between states in terms of court systems?
So the answer to your first question, have state courts changed over time? I don't know that I can give you a historical over the course of time type of overview for 50 different states. Here's what I can tell you. The general model of state court systems that I described, state trial courts, appellate courts, Supreme Courts, that's a model that, with some significant variations, goes back well before the founding of our country. If you were to go back to the 1700s or even to the 1600s, you would find something that would be recognizable to you as a court system. And you would similarly, if somebody from that time period came here, they would walk into one of our courts and they would say, okay, the details are different. There are variations, but they would recognize we're going to have a trial. We're going to have people come in and present their evidence, present their testimony, and either ask a judge or a jury to make a decision. They would recognize that. Then they would also recognize if the losing side thinks something went wrong, they have the right to ask another set of judges in an appellate context to correct whatever that alleged error is. And then they would also recognize we also have a Supreme Court that's the ultimate authority. If you were to go back to England or to the colonial period, in theory, people had the right to appeal back to the King of England in many instances, ultimately. So that's the first piece. What accounts for differences or modifications in that? There are a number of different thoughts in it, but it really comes down to what do the people of each state think is going to functionally work. There's nothing magic about how you structure a court system. We just have various ways of doing a court system that have been tried over hundreds of years and seem to function. But you will see in some states, you'll have specialty courts. Think something like, and they may be independent courts or they may be subsets within a court. Think something like some states will have a municipal court, and what they will deal with is literally things like violation of parking rules. You park your car in the wrong spot, you go to municipal court. We're not going to take you to the trial court. We're going to have a special court set aside just for that. They might do that for something like, for instance, they might have a lot of volume, lots of cases coming through really quickly, and they need a dedicated place that can do a really good job of handling many cases quickly. That might be one idea. You might also have, for instance, you might have something like Texas, where they've said, we've got a Supreme Court, it's not called the Supreme Court, but we've got a court that is the ultimate authority on criminal issues. We want to have someone set aside, or judges set aside, to think about legal issues in the criminal sphere. This goes back to Janine's question of how do you develop a subject matter expertise if you are dealing with many different issues all the time? So that's another reason that you might structure a court differently. You might say that's what we want to do. And you can have informally, you can also break up courts. So for instance, in my court, the way we are structured, not because of anything required in the Constitution, but just because practically this is how we arrange it, is we have different judges who hear similar types of cases repeatedly. So you'll have a misdemeanor court that will hear essentially alleged crimes where the person could be sent to jail for up to a year. And that's the only type of case that person will hear. Now, that judge will move from that court to a different kind of court at various points in their judicial career. But for right now, they're hearing all of those cases. And so they'll develop a familiarity with that. So that's some different ideas in response to your question. Does that answer some of what you're looking for?
Absolutely, thank you. And then if citizens of a state are, say, dissatisfied with some aspect of the court system and they wanted to change it, is the only opportunity to change it through a constitutional amendment to their state constitution, or are there other ways of doing that?
It's going to depend on how those court systems were originally set up. So in Illinois, for instance, where I am, the state constitution is what establishes how the court system is constituted. Supreme Court, appellate court, trial court. If you wanted to change that, you would need a constitutional amendment. Now, short of that, citizens can impact how the court system works in a number of different ways, because the overwhelming majority of the time, what we're doing is applying laws that are passed by the state legislature. So in a particular subject area, if there is something that a citizen thinks should be changed, typically that's going to be a matter of talk to your legislators, get your law passed, and that would be the method to modify something like that.
Great, thank you. And then this is more of a technical question, but do courts for a certain state deal with issues that like happen within their borders, or is it citizens of the state? Like if someone from Texas came to Illinois and an issue arose, would that be dealt with by, like, what court would that be dealt with?
So you're asking, it turns out that that's actually a very difficult question to answer sometimes, because you're talking about the court's jurisdiction, which is just a fancy word for saying, does the court have the power to resolve this disagreement? Typically, what will happen is there has to be some kind of a connection to the location where the court is. That will mean something like one of the parties, one of the people involved in the litigation lives there, or the incident that happened or that's alleged to have happened, the crime that is alleged to have been committed, was allegedly committed in the location where the court is. Or there's a piece of property that the parties are fighting about that they both say that they own, and that property is located where the court is. But a court will, and I'm speaking in general terms, obviously, but a court usually will not and cannot resolve a case unless there's some connection of some kind to the jurisdiction, to the location where the court is. And what that connection is can become very complicated and become very messy. But in broad terms, think of it as there's got to be a person where the court is who's involved in the suit. There's got to be a thing that is involved in the suit, or there's got to be an event that took place where the court is located in order for that to be a proper place for the lawsuit to be heard.
So does the state to which a plaintiff or a person belongs to, does that matter for jurisdiction?
Yeah.
It does, okay.
You can.
And then we've talked on constitutional chats a lot about the fact that Americans file a lot of court cases compared to other countries, and how it's kind of just, as I'm sure you know, a well-known aspect of America. So in your opinion, why do you think Americans feel empowered to submit so many court cases relative to other countries?
I don't know that I'm qualified to speak for what's motivating my fellow citizens in that regard. I think that if I were to venture a guess, one thing that has been suggested is, well, there are certain things that you can do to make litigation more or less likely. One of the primary things you can do is ask who is going to pay for the cost of litigation. So in America, typically both sides pay for their own attorneys. Typically, there are some very important exceptions to that rule, but usually if you're going to have a lawsuit or you're involved in a lawsuit, you're going to pay your attorney, the other side is going to pay theirs. In some other countries, the loser pays both attorneys. So if you're bringing a lawsuit, you're incentivized to make sure that you think you've got a good claim, because you know that if you don't and you lose, not only you're going to pay your attorney, but you're going to pay the other side's attorney. And the cost of litigation can be extremely high. Cost for hiring an attorney could range anywhere from just ballpark numbers. A couple $100s an hour would be relatively inexpensive for an attorney, to some attorneys who are representing very large companies in very, very expensive litigation could be well over $1,000 an hour. So multiply that times hundreds or even thousands of hours of lawyer time, and you can get very big numbers. So that's at least one thing that's been suggested as at least a factor that determines whether and how much litigation you have.
Great, thank you. You answered all of my questions, so I will now pass it on.
Hello, thanks for talking to us today.
Well, thanks for letting me be here.
We have been talking about the court systems, as you know, and we were talking about federalism before this. We covered the anti-federalist papers. And because of that, that's been my greatest interest, is the relationship of the court system to federalism. So we talked about the federal court system, and now we're talking about the state court system. So one of my first questions is, you talked about a case that is under the state jurisdiction. The Supreme Court should not, will just say we don't have jurisdiction over this because it has to do with state law. It can't be appealed federally. Can you think of a few examples for your state of where someone would think, hey, maybe I can take this to the Supreme Court, but in all reality, it's a state issue?
Sure, there would be an overwhelming number of cases like that. And what you really want to be looking for is, well, the way lawyers would think of it is they would think of it in terms of, is there a federal question? So when in my opening comments, I said, you have to have a hook to get into federal court. You have to have a reason to be there. If you don't, at least the presumption under principles of federalism is you're going to be in state court. So for example, if you are alleged to, well, let's take a different example. Let's say that you have a child custody dispute. And two parents are arguing as to which of them should spend Christmas with their son or daughter, and the parties are divorced. Okay. That question is entirely governed by state law. There won't be or at least I'm sure there is an exception, but in general, that issue is going to be determined by a law passed by whatever state the parties live in. And if you take that case and you try to say to a federal trial court or a federal appellate court or the federal Supreme Court, please decide how we deal with this issue, they're going to look at it and they're going to say, no, this is an issue that is supposed to be resolved by the states, because this area of law is one that is left for the states. Because remember, if you go back and you look at the Constitution, all powers not expressly given to the federal government or prohibited to the states are reserved for the states or for the people themselves. So if you think about it in those terms, the question is not why isn't this in federal court? The question is, why should this be anywhere but state court? And unless you can answer that question, it's in state court. So I don't know if that answers your question, but that's my best shot at it for now.
Yeah, it does, and it sets up the next one, which is definitely a little bit more complicated, maybe. So we covered that basically to have a sovereign nation made up of sovereign states, the Supreme Court was going to have supreme jurisdiction over the powers that the Constitution granted the federal government, which means that in a conflict between the states and the federal government over something that the federal government has jurisdiction over, the states are subject to that rule.
You're talking about the supremacy clause.
Yes. And if basically, as we looked at those papers and we talked to many smart people about it, there didn't seem to be, it seemed like, yes, if we were going to have one nation, that's a necessary thing. If we were going to have even a federal system, that was a necessary thing. That's lays the power of the federal government. And then, as you know, the states are meant to have, like you just said, those other powers. The federal government only has the enumerated powers. Fast forward the clock, these however many years, and now here we are in 2021, and the federal government has been able to find in the Constitution and however many Supreme Court rulings a large breadth of powers, which would not have been foreseen by the founders who wrote the Constitution, who thought of this system, but it was defended under clauses like the Commerce Clause and other clauses of that nature. So as soon as the Supreme Court does rule that yes, on something, and it claims that it has power over it, even if the founders would not have envisioned it that way, even if it is really stretching that document, in the system, there is really no recourse for the states then, because of what we just talked about in the supremacy clause, which is kind of still a necessary clause. So my question to you is in thinking of that, how is the people of the country, how are we meant to, is it only through elections that we were meant to regulate that? Because a bad Supreme Court can say the federal government has any power that is, if the law is passed, it's unconstitutional, and the Supreme Court says it's constitutional, states really do recourse. Only recourse actions is your.
So you're breaking up a little bit there, but I think that I've got some of the gist of it. The question essentially comes down to, what recourse do citizens have if they believe that really any governing authority has exceeded its power? And the challenge that you have there is that, as you noted, when you referenced the supremacy clause, at some point, if you're going to institute a government, you have to put the final decision-making power somewhere. And once you do that, then you have a problem. And this is the problem that goes with self-government throughout recorded history. And people have developed different models to try to address what they perceive as the risks from, whether they call it abuse of power or tyranny or what have you. You go to the ancient Greeks and you can talk about democracy there, or you can go to checks and balances and talk about that. But the short answer is that once you put ultimate authority somewhere, you don't have, somebody has to be the final say. This is the buck stops here notion that you may have heard of. In the federal system, the founders structured it with the checks and balances that you've discussed previously, and the notion being that we can't create a perfect system that solves that problem of where we deposit authority. All we can do is, as was famously said in the Federalist Papers, make ambition to counteract ambition. And so you have different pieces of the decision-making authority in different branches of the government. I think of the admittedly somewhat flippant statement that President Andrew Jackson is said to have made when he heard about a Supreme Court decision that Chief Justice John Marshall made, where Jackson is reported to have said, "The Chief Justice has made his ruling, now let him try to enforce it." Now, that is a very frightening statement if you think about it, but it highlights that there is always this tug, this push and shove between the president as the executive power, the legislature as the ones who pass the laws, the judiciary as the ones who interpret the laws, and also very importantly, between the states and between the federal government, where they are in constant state of flux, trying to essentially make a more perfect union and to strike that balance. But the short version is, you're not going to ever have a perfect solution to that problem of where do you put the ultimate power. All you can do is attempt to compensate for the challenges that you will have when you have ambitious, highly competent people working in government. And that's really the genius of the federal system that was set up in the Constitution is at least the best attempt that anyone has managed to come up with to date as to how you make those different ambitions counteract each other and therefore compensate for the inevitable growth or the inevitable attempt to grow that you're going to see in government officials, even government officials of very good faith.
Thank you. It is an imperfect world, so we can't have a perfect system. And we're always amazed, I think, as we learn of every nuance that the founders had thought of, and every practical solution and compromise that they came to not allow them to basically throw the baby out the bathwater, that they gave us something that created the strongest. I think you could state objectively that we have the strongest system of government that's ever been created in human history.
Well, you could certainly say the longest standing constitution in history. It's lasted longer for all of its modifications and all of its tweaks and all of the changes that have been made, both officially in the document and changes in how government practically functions. You're right. Objectively, the United States government under a single document is the longest currently standing.
I think that that of course the Civil War did a lot of damage to state sovereignty moving forward and state powers in modern thinking. Even today, looking back, a student definitely comes away with an idea that it's maybe a dangerous idea for states to have a certain amount of power vested in them. But at the same time, we've seen so many good aspects of subsidiarism, whatever you call it, where the states have that power and that sovereignty. Do you think that as a state judge, do you think that there's an issue today of the states not having enough sovereignty or enough vested powers based on not so much the system, but also just what the electorate expects?
I don't know that I can give you a general answer to that question. The only thing I would probably note is when you reference the Civil War, scholars debate constantly how much of a change did that make. And the only thing I'd point to there is, well, we ended up passing the 13th, 14th, and 15th Amendments in response to that. And if you talk to a lot of legal scholars, they will tell you that some will even go so far as to say that that is really America's second constitution. You can debate that and you can argue about what that means and how that impacts it, and people continue to do so. But you're at least right that there is, that's a change that you have to address. In terms of state courts and how they function, I would probably go back to just some of the initial comments that I made, where I referenced that state courts are by far the workhorse of the judicial system, and particularly state trial courts. And I mentioned the case filing numbers. That's not a perfect measure, because it doesn't tell you about how hard or how easy those cases are, or how long they last. But just in order of magnitude, we're talking about millions of cases versus thousands of cases in the federal system. And I think that what you see from that is another thing that I mentioned at the outset, which is for your average citizen over the course of their lifetime, a state court system is going to be far more likely to be far more important in their life than the federal courts. That's not to say that the federal courts are unimportant, because the federal courts clearly decide major issues that impact everyone everywhere. But if you are in a court system, as heaven forbid, part of litigation, the good likelihood is that you're going to be in a state court system. And that suggests at a minimum that the states continue to have an incredible amount of importance and authority and impact on the lives of their citizens. Think of it as the sort of quintessential American picture of what even a courthouse is. If you think of a courthouse, you're probably going to think of a Norman Rockwell painting that is this beautiful building from 1885 on some quiet square in the middle of town with storefronts dotted all around it. That's a state court in all likelihood. And that's what the court system is to your average American. If you ask somebody in my community, where's the courthouse? They're not going to tell you it's the Dirksen Federal Building downtown Chicago. They're going to tell you that it is the 18th Judicial Circuit Court sitting in Wheaton, where I am, because that is the court system to your average American.
All right. Thank you very much. We have some audience questions now, I believe.
Okay.
Yeah, thank you. Thank you so much, Joel. First of all, Sanford Thatcher asks, under what circumstances can a criminal case already heard in a state court system be appealed to a federal court?
Good question. So here, and at a very high level, here's the answer. Typically, if you've got a state criminal case, you're going to come into a trial court like my courtroom. You're going to have witnesses, and the witnesses are going to come in and they're going to say, here's what we saw, here's what happened. And then, assuming that the person has asked for a jury, the jury is going to decide that person is guilty or they're not guilty. If the jury decides that person is not guilty, case is over. We're done. It doesn't go anywhere. If the jury decides that person is guilty, then that person is going to be sentenced. At that point, that person that defendant has some options. They have to first appeal within the state court system. So that means that in my court system, they would ask the appellate court, please fix these problems that we think happened at trial. And those problems could be matters of state law or matters of federal law. They could say, for instance, my Fifth Amendment right against self-incrimination was violated in some fashion. That's a federal constitutional right. They could also say the judge misapplied or misinstructed the jury as to the elements of the Illinois law for aggravated battery. That's a state court. That's a state law question. They can take both of those questions to the intermediate appellate court. The intermediate appellate court is going to rule on both of those issues. If that individual thinks that the intermediate appellate court got it wrong, they can ask the state Supreme Court to address those same issues, both the federal issue and the state law issue. The Illinois Supreme Court is going to do one of two things. They'll either agree to hear that case and they'll make a decision, or they'll decide, nope, we're not going to hear this case. The appellate court is the final answer here. We're done. Either way, at that point, the Illinois Supreme Court has had its final say. At that point, that person has an option. Remember, they brought two claims to the court. One was a federal Fifth Amendment issue, self-incrimination. The second was, did the judge properly instruct the jury as to what Illinois law requires for aggravated battery? At that point, that second claim, what does Illinois law mean, is over. And there's nowhere else to go with that claim. The Fifth Amendment claim, you can still ask the U.S. Supreme Court to hear that decision. And the U.S. Supreme Court will decide whether or not to grant that decision. And that's beyond the scope of, what the Supreme Court looks at in deciding whether or not to take a case is beyond the scope of what we're talking about here. But that's your direct set of appeals. Now, we have a whole second set of issues, which are called collateral review, which is another way of saying, once you're done with your appeals, you can come back and you can ask to reopen the case for various reasons. You can do that both in state courts and in the federal courts. The details of that get very messy very quickly, but the bottom line is you will still have, in general, the same distinction between, is there a state law issue, in which case the state courts are going to resolve it, or is there some federal claim you can make out that your constitutional rights were violated in some fashion, or that there was some other federal violation? Short of that, we're going to be in state court. It's a good question, and the first part's easy. The second part, when you start talking about collateral review and the writ of habeas corpus, gets very, very messy very, very quickly.
Yeah, no, thank you for that answer. I felt like that really cleared it up because I was wondering about that myself. Now, Vicki Sanders asks, where is information on decisions of judges in the states found? If in a state where judges are elected, more information than a small article in a newspaper is needed to make a choice. And that's a really good, I think that's a good point.
It's a good question. And the information about state court actions is significantly less than what you would see for federal courts. And it's gotten a lot worse. So if you were, and it's gotten a lot worse with, unfortunately, the internet, which lets us talk here today, but really hurt local news gathering, because that would have been your primary source of information. So back in the day, if you were to go 30 years ago, here in my courthouse, on any given day, we would have had a dedicated reporter here for the Chicago Tribune, the Chicago Sun-Times, the Daily Herald, which is like the regional paper in this area. And then we would have had a number of town newspapers. We would have had the Wheaton Leader, the Glen Ellen News, the Naperville Sun. Those were all papers when I was growing up here. And there would have been 3, 4, 5, 6 reporters in the courthouse on any given day covering trials. Now, if you go around the courthouse, you won't see any news reporters unless there is a major case that is of major public interest, such that the Associated Press sends somebody, or such that the Chicago Tribune sends somebody out from Chicago to cover the particular case proceeding. That is a real loss to our society. That is a function of, well, this is beyond the scope, but one of the many things is those newspapers depended on advertising revenue, and most of that advertising revenue now has gone online, where you can reach far more people for far less money. And as a result, a lot of those smaller news sources have dried up entirely, and the larger news sources have fewer reporters. So where do you go to get information? The appellate court decisions and Supreme Court decisions in pretty much any state are published on those courts' websites. So you can always get information about the decisions that they've issued. If you want to know what's happening in a trial court, you can always go to the trial court and you can walk right into the clerk's office and ask to see their docket. Now, their docket is going to be thousands upon thousands upon thousands of cases, and it'll be the paper record of whatever happened there. But you can go look at that, and if you know a particular case, you can go look it up. And then the last thing is, courtrooms in America have always been public and should always remain public. So if you want to go and you want to watch a trial, you're more than welcome to do so. They might have a coronavirus restriction at this point in some sense that might modify how that's done. But I can tell you that if you show up in my courtroom today, my courtroom is open. You're more than welcome to sit there and watch whatever's happening and see what you think of the process.
Well, thank you for that. And one of our listeners, Mary, encourages everyone to buy their local newspapers so that we can keep them open and keep them reporting.
She's not wrong.
I know, Judge, you've actually got to go to work here in just a couple of minutes. You've got to go, I guess, are you actually sitting on the bench today?
Yeah, I have a trial that I started yesterday afternoon, and it's continuing today.
So we want to make sure that we let you off the chat with plenty of time to do that. And we want to thank you so much for being our guest today. And Janine, do you have any closing words?
Yes, I'll just say, Judge Skarin, this is one of my favorite podcasts. You were simply terrific, and I learned. Can you not hear me again?
I can hear you for a second. I heard the part where you were effusive in your praise, and I'm going to take that with a grain of salt. But thank you.
No, it was true. This has been one of my favorites. You've just done a fantastic job. And also, I feel I learned so much. Just thousands of little nuggets in here that were truly thought-provoking. So I thank you for your time so much and for your service.
Well, thank you for having me. I really enjoyed it, and I really appreciated the opportunity to be here. So you have a good rest of the afternoon.
Thank you. You too. Thank you so much.
And we're going to let you go ahead and feel free to jump off.
All right, I'm going to jump off.
And if I could just put a quick plug in for our online auction, and Aubrey, I'm gonna surprise you, but if you wanted to bring the website up just really quick, we want everybody to know that if you enjoy our programs with Constituting America, we have an online auction going on between now and 10 p.m. on Thursday, November 18th. We've got a lot of really great items, and to access it, all you have to do is go to the homepage of our website and click where Aubrey's about to click. It says, click here for our online auction. And if you click that, you can see all the great items that we have, and we are a little over halfway to our goal. We've got some really cool pins that are made from wood that actually was in Independence Hall. We have all kinds of veteran-owned businesses that have donated and that we're auctioning off items. And then we've even got a guitar signed by John Rich. So please go on and bid. And if you don't have time to make a bid, you can make a donation right there on the auction site. So hope to see y'all all on our auction. And Janine, is Jewel, Jorn, anybody want to say anything else?
I'll just say those are great auction items. Can you hear me? Those are fabulous auction items. So gosh,
Yeah.
a guitar by John Rich from Big and Rich, and a pen from wood from the Independence Hall. That's fantastic.
Yes, there's a company called History Salvage that donated those pins, and they're a great Mr. Bob Martino. He's actually one of our regular Constitutional Chats listeners, and he donated the pins to us, which was just a wonderful donation.
Yes, thank you for that. Thank you so much. And what a great show. I don't know if Jewel wants to sign off, but thank you everyone so much.
Thank y'all. And we won't be having our chat next week for Thanksgiving, but we'll be back on Tuesday, November 30th. So everyone have a wonderful Thanksgiving.
Happy Thanksgiving. Thank you.
Bye.
Bye.